Welcome to our first case study together with Paraphrased. I'm super excited to go over this with you guys today. This is actually a case that I picked a couple weeks ago, and I knew that there was going to be some clarification on the Pregnancy Workers Fairness Act that would be coming down. It was actually supposed to happen in February, but it just happened a couple days ago. But I still want to go through this and talk about it. And then I'm probably going to do another video within the next couple of weeks to go over some of the changes and what you need to know as a business about pregnant workers within your organization, because there is a lot to know that's really changing significantly. And so it's important that you know what to do when an employee is pumping or when they need an accommodation. And so let's talk a little bit about a 2014 case, Peggy Young versus UPS. So 2014, Peggy Young was a part-time driver for the United Parcel Service. She became pregnant and was advised by her doctor that she was unable to lift anything over 20 pounds. As you can imagine, as a delivery driver, they are requiring you to lift 70 pounds. And so 20 pounds to 70 pounds obviously is a huge difference. And so instead of engaging in a process with Miss Young or looking at any type of light duty or accommodations that they could make, they put her on leave, an unpaid leave. And so Miss Young obviously wasn't very happy with that. And so she decided that she was going to take matters into her own hands, hire an attorney, and go after UPS for discrimination. So she actually claimed that she was the victim of gender discrimination as well as disability discrimination under the Americans with Disabilities Act. So there's also a Pregnancy Discrimination Act as well. And so it kind of fell under both of those is where she was going with that. The Pregnancy Discrimination Act of 1978 had amended Title VII of the Civil Rights Act of 1964 to prohibit discrimination on the basis of pregnancy, childbirth, and related medical conditions. So UPS moved for summary judgment and argued that Miss Young could not show that UPS's decision was based on her pregnancy at all, or that she was treated any differently than anyone else that was similarly situated. They also argued that they had no obligation to offer Miss Young an accommodation because pregnancy is not a disability. And the court agreed. They ended up dismissing the case. And so she went on to appeal, and she went to the U.S. Court of Appeals, and they also affirmed that. So they also agreed that this was not a case that they were willing to hear, and they also dismissed it. So Miss Young then petitioned for a review, and it ended up going to the Supreme Court. And that's when things changed pretty drastically. So the Supreme Court decided in a 6-3 decision that Peggy Young was in fact discriminated against because she was pregnant and asking for an accommodation. They held that UPS's policy denied accommodations to pregnant workers while accommodating other employees that were similarly situated and had similar restrictions, mostly for workers' compensation claims. So a lot of times, as most of you know, when someone gets hurt at work, then of course you want to put them on light duty if that is something that you are able to offer them. And so they were doing that for other employees, but they weren't willing to do that for Miss Young because she wasn't hurt at work, and they were saying that it wasn't a disability. Pregnancy isn't a disability. So this obviously was pretty impactful, and there was significant implications that came out of this because it really was telling employers, you have to accommodate pregnant employees just like you would someone with a disability or someone that was hurt at work. And so that was kind of the message that was being sent. And it really prompted employers to review their policies and practices regarding pregnancy related accommodations, and just to make sure that they were doing things legally above board, and obviously to avoid any potential discrimination claims in the future. And so the Pregnancy Worker Fairness Act, then this is where things kind of get even crazier. So fast forward to recent times where we now have a Pregnant Workers Fairness Act that was approved and makes clear that pregnant workers are entitled to accommodations to keep doing their jobs, mirroring the process essentially for workers with disabilities. And obviously, there is a ton more to this because there is also some language in that was just pushed down within the last couple of days to clarify some of the things in the Pregnant Workers Fairness Act, which talked about if you have a light duty program that you're doing for workers' compensation, you also need to make sure that you are letting people who are pregnant engage in that same process. And so there's a ton of stuff that is coming down out of that, and it is very, very intricate, very detailed, and something that I'm going to do a video in the future on, because I think it deserves its own space. But it's really looking at undue hardship as well. And as we know, undue hardship really can be such a challenging level to kind of determine. And a lot of times it ends up not being undue hardship, even if it feels really heavy for the employer. Obviously, there have been cases that have been won with undue hardship, but it is a hard standard to kind of wrap your head around and decide if it is in fact something that's going to be arguable in court. So that's a topic for a different day. What I'd like to leave you guys with today is this. If you have an employee who is pregnant and needs some type of an accommodation, it is incredibly important that you have someone like me in your court. This is the kind of stuff that I can help you guys with. I can help you move through. I can help you create a process. And if it goes outside of me being able to help you, I certainly have the right attorneys that can help us maneuver through this as well. So if this is something that you are concerned about, please reach out to me. I do have a subscription program, and I have a lot of employers on this where they get an hour of my time a month. And this is some of the stuff that we talk about. We obviously talk about things that are going on with their organization as well, but when things get pushed down from HR, these are things that I also share with them and let them know how this, in fact, could impact them as an employer. So I'm excited to share the first case study with you. I hope that you found it helpful. I will be doing another video in the very near future on the Pregnancy Workers Fairness Act as well as the Pump Act, because there were a lot of changes to that as well. Much more strict criteria on what you are required to provide a woman who is pumping or breastfeeding their baby. You used to have to give them time. Now there's a lot of requirements that you have to make that area or that space that they are pumping in look like. And so that's something that I'm also going to cover in the same video. So if you have questions, please reach out to me. If you have any comments, please reach out to me. If you have any experiences like this that you'd like to share, I would love to hear from you. I'm sure people who are watching this would as well. I hope you guys have a great day. Stay out of trouble out there.